Hi, my name is Jane McElligott. I teach legal studies for the School of Social and Behavioral Sciences with Purdue University Global. And I will be talking about the recent affirmative action decision of the Supreme Court. Um, and this is part of our continuing SCOTUS series. So this case was brought by Students for Fair Admissions against Harvard College. In one case, it was combined with the same group suing University of North Carolina. Before we get into the facts a little bit more deeply, I'd like to just talk about the history, the laws involved in this case. So going back to the civil rights era, it saying that the 50s and early 60s, it became clear that federal legislation was essential to protect individuals from discrimination in the workplace, education, places of public accommodation. So that's when the Civil Rights Act of 1964 was passed. And it had several titles. Title I dealt with prohibiting discrimination in places of public accommodation, so restaurants, hotels, buses. Title VI was aimed to prohibit discrimination on the basis of race, color, or national origin in any education program that receives federal funding. And finally, Title VII prohibits discrimination in the workplace. So if we look at the wording of Title VI, it states that no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So this is one law that the Students for Fair Admissions, and I'll refer to them as SFFA because it's a little bit easier than saying the whole name. They contended that the affirmative action programs of Harvard and University of North Carolina, UNC, violated Title VI of the Civil Rights Act. We'll talk more about their theory on that. After the Civil Rights Act was passed, President Lyndon B. Johnson made a famous speech at the time at Howard University, and he mapped out the concept underlying affirmative action, and he explained the basis for it and why laws that prohibit discrimination alone are not enough, that more is needed. And so in his speech, he said, you do not wipe away the scars of centuries by saying now you are free to go where you want, do as you desire, and choose the leaders you please. You do not take a man who for years has been hobbled by chains, liberate him, bring him to the starting line of a race, and say, you're free to compete with all the others, and still justly believe that you have been completely fair. This is the next and more profound stage of the battle for civil rights. We seek not just freedom, but opportunity, not just legal equity, but human ability, not just equality as a right and a theory, but equality as a fact and as a result. So that's really the basis for affirmative action, acknowledging that due to discrimination, there is not equal opportunity. And just as this was stated back in the 1960s, we know that equal opportunity is still not present. We've made headways, but it is still sadly not present in this country. So the Equal Protection Clause is the other law at stake in this case. So the plaintiffs, the SFFA, claimed that the Harvard and UNC affirmative action programs also violate the Equal Protection Clause. So the Equal Protection Clause of the 14th Amendment, this was passed after the Civil War to help with Reconstruction, to provide equality, to provide rights for African-American individuals at that time when it was clear that such not legislation, but a constitutional provision was necessary. And the wording of this provision is no state shall deny to any person within its jurisdiction the equal protection of the laws. And just as it really means exactly what it how it looks, it's basically saying the state cannot deny a right to one class of persons that it provides to other classes of persons. Now, there may be situations where there is a justifiable reason for differential treatment. So if you take something, for example, a state law that requires motorcyclists but not automobile drivers to wear helmets. So that could usually be, and those laws have been challenged, but they're usually upheld by saying that, well, it makes sense. There's a likelihood of a risk of a serious head injury to a motorcycle rider without a helmet than a person in a car. Person in a car, of course, has a roof over their head. So the public health consequences justify that differential treatment. And because race or national origin, they're not at stake in a law like that, so the state only has to prove a rational basis to uphold that law. And so that's not a very tough test to pass. But when differences are made either in a statute or in a policy based on race or national origin or sex, although sex has if there is a distinguishing factor on sex, it gets intermediate scrutiny. The highest scrutiny goes to race or national origin. Because really, there's no justifiable reason, and we could really say that about sex as well. There's not a justifiable reason for different treatment, unless it's a beneficial or benign purpose. And that's why affirmative action has been upheld by precedent. The thought is that we have had injustice, inequality, so affirmative action is beneficial because it remedies that past discrimination. And also, as we'll see, one of the justifications for affirmative action, actually the main justification, is to create educational diversity that, of course, improves the learning experience for all students. So challenges to policies that are based on race, such as affirmative action programs, have to pass what is called the strict scrutiny test. And under that, the government, and so here the universities have to show, because the universities are getting federal funding, they have to show that the challenge classification, the affirmative action program, serves a compelling state interest, and the classification is necessary to serve that interest. So you can see that's a difficult test. So looking back at precedent, the Bakke case, Bakke versus University, the Regents of California, this is a 1978 case, really the first case on affirmative action. It was a little bit of a messy decision because there was no majority decision, but Justice Powell wrote the plurality opinion that got the most votes. And in doing so, he really paved the way for future affirmative action cases. This case involved Alan Bakke, who was a 35-year-old white man. He had applied twice for admission to the University of California Medical School, was rejected both times. The school had a system where they reserved 16 out of 100 seats in each entering class for qualified minorities. And so this was really the main part of their affirmative action program. So Bakke's qualifications, looking at his college GPA, his test scores, exceeded those of the minority students who had been admitted in those 2 years where he was rejected. So he challenged this, saying it was discriminatory and in violation of the Equal Protection Clause. And so SCOTUS jumped in on this one again. Justice Powell wrote this plurality decision and held that the medical school discriminated against white applicants by excluding them from the 16 out of 100 seats. So those 16 seats created a quota in the eyes of the court. So the court said, this type of program, it can't be done. You can't have quotas. But SCOTUS made it clear that it is constitutionally permissible for universities to consider race as one criterion, so a plus factor, along with other factors. So just as geographic diversity, whether the parents are alumni, whether you can play a particular sport, are you from a different country, all of these things are considered as factors. And so race can be one factor. Again, for that purpose of creating the environment where we learn better when there's diversity. The court has reaffirmed its holding in Bakke in a couple of key cases. Grutter versus Bollinger, Fisher versus University of Texas was the most recent in 2016. And in both of those cases, they held that race can be considered a plus factor, among other factors, just no quotas. So SCOTUS has consistently upheld challenged affirmative action policies to be justifiable to ensure educational diversity. And the court has been steadfast in holding that educational diversity is a compelling state interest. Now, in comes this recent case to kind of throw upheaval into all of the precedent. So in this case, the Students for Fair Admissions, the SFFA, was actually founded by a conservative anti-affirmative action activist, Edward Bloom, who actually also brought the case Shelby versus Holder, which you may have heard of, that greatly restricted voting rights. So he brought suit in the U.S. District Court in Massachusetts, challenging Harvard, and in North Carolina against University of North Carolina. So SFFA challenged both of these affirmative action programs in their specific jurisdictions. And so SFFA contended that race-conscious admissions programs, again, in which race is considered one factor among many as a plus for admission, violates the Equal Protection Clause and Title VI of the Civil Rights Act. But the court said no. The U.S. District Court in Massachusetts and in North Carolina both ruled for Harvard and University of North Carolina, and they found that affirmative action programs were in complete compliance with precedents set by SCOTUS, and they did not violate the Equal Protection Clause or Title VI. So SFFA then appealed both decisions to the federal courts of appeal. The U.S. Courts of Appeal for the First Circuit affirmed the district court's decision, so that it continued to rule in favor of the universities. Before the Court of Appeals for the Fourth Circuit for North Carolina could even rule, SCOTUS granted certiorari to hear this case. So it made its way up to the Supreme Court at that point. So in its decision, majority of the justices of SCOTUS, it was a 6-3 decision. There's quite a few separately written opinions, but the weight goes to the opinion written by Justice Roberts, Chief Justice Roberts, in effect ended affirmative action as it is practiced by most universities, where race is considered one plus factor among several other factors. Justice Roberts, in this case, reached the conclusion that Harvard's and UNC's affirmative action programs lack sufficiently focused and measurable objectives warranting the use of race. They unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. Even though, as the dissents bring out, there's no negative from affirmative action to other students. It's just a plus for students who deserve the plus factor based on race, just as they would for geographic diversity or other reasons. When one reads the majority opinion, you think you kind of have an understanding of it, and then you read the dissent, and they bring up so many issues that make you question the majority opinion so much. And we'll take a look at some of the statements made by the dissenters in this case. Roberts ruled that the affirmative action programs of both institutions violate the 14th Amendment and Title VI of the Civil Rights Act, and held that college admissions program can consider race only through student essays describing how race has impacted the students' lives. For example, how they have overcome discrimination. So basically, again, this decision by the court in effect overrules it. The court didn't explicitly say it was overruling Greta versus Bollinger, the key case on affirmative action, but in effect it does, because it's saying that what universities are currently doing is unconstitutional. So in that case, in Greta, SCOTUS had upheld University of Michigan Law School's affirmative action program. And again, its main reason is because the university considered race as one factor among many in an effort to assemble a student body that is diverse in ways broader than race. Again, because diversity encourages better learning. We learn from each other in that way. And up till this decision, that has been enough to uphold affirmative action. When it comes to the dissents, there were very powerfully written dissents by Justice Sonia Sotomayor and Justice Ketanji Brown Jackson. Just some of her best quotes. I think this is my favorite on the bottom. In a society where opportunity is dispensed along racial lines, equality cannot be attained through race blindness. And that was kind of the gist of the majority decision, is that we should, having affirmative action is racism in itself, and we can no longer have any kind of distinctions about race. So this kind of race neutral, colorblind approach. But as Justice Sotomayor brings up, it's when society still has inequality based on race and lack of opportunity based on race, one can't obtain that by just going to the race blindness approach. And so, as she said, the devastating impact of this decision cannot be overstated. The majority's vision of race neutrality will entrench racial segregation in higher education, because racial inequality will persist as long as it is ignored. And ignoring race will not equalize a society that is racially unequal. That what was true in the 1860s and again in 1954, the time of Brown versus Board of Education, is true today. Equality requires acknowledgement of inequality. And Justice, one other quote from her: today, the court stands in the way and rolls back decades of precedent and momentous progress. It holds that race can no longer be used in a limited way in college admissions to achieve such critical benefits. So her dissenting opinion is just amazingly written and bringing up all of these key issues that the majority opinion kind of tries to roll over. Justice Ketanji Brown Jackson dissenting opinion was also so well written and powerful. She said that with "let them eat cake obliviousness today, the majority pulls the ripcord and announces colorblindness for all by legal fiat. But deeming race irrelevant in law does not make it so in life. The best that can be said of the majority's perspective is that it proceeds ostrich-like from the hope that preventing consideration of race will end racism." So Justice Jackson really, she called out the court for its revisionist history, in which the court ignored the fact that the 14th Amendment, the Equal Protection Clause, was implemented following the Civil War really for the very purpose of ensuring African American individuals would be treated equally under the law. The SCOTUS majority interprets the Equal Protection Clause in this type of colorblind manner that ignores the history of racism and the continuing inequality that really flows from that racism and discrimination when it comes to educational opportunities. So Justice Jackson also spoke to the ahistorical opinion, asserting that the Equal Protection Clause requires no consideration of race, which is the approach of the majority. And she said that view that we can't consider race at all will obstruct our collective progress toward the full realization of the clause's promise, truly a tragedy for all. So really, in the eyes of both Sotomayor and Justice Jackson, is the fact that these measures, the affirmative action measures, the case law, have been working and have been making progress. To just put an end to affirmative action at this point is not a good approach, because we are not at that point yet. Is the main message of their dissents. And if you're thinking of reading the case, it's a very long case, but it is an amazing case to read, and I would highly recommend reading the two dissents by Sotomayor and Jackson, and Justice Elena Kagan joined the two dissents as well. But just a quote there to recognize really the whole idea of affirmative action, the whole reason it has been upheld over the years, ever since Bakke in 1978, is because of the idea that it's students learning in an environment where they can accept and celebrate the differences. We all learn so much better in that way. But by shutting down affirmative action, the fear is that this could really bring back the progress that has been made. Of course, colleges and universities can still persist in affirmative action by encouraging student essays that touch upon their the way that race or national origin has impacted them. So hopefully it can just be kind of a workaround, but it still is disappointing, because the way that affirmative action has worked, and it has worked for several years, is now kind of all upended. So thank you for listening. That is all I have.